Here.
Pinole,
Here.
Pittsburgh,
Present.
Pleasant Hill,
Here.
Richmond,
Here.
Ross, San Anselmo, San Pablo, San Rafael,
Here.
thank you, San Ramon,
Here.
thank you, Sausalito,
Here.
County of Solano,
Here.
Tiburon, Vallejo, Katie, Vallejo,
Here.
thank you.
Sorry, I'm having internet issues.
Okay, we can hear you. Walnut Creek,
Here.
roll call complete. Quorum established.
Okay, so this is the MCE Board of Directors meeting. If you're not here for that, you're in the wrong meeting. This Board of Directors meeting will be conducted pursuant to the provisions of the Governor's Executive Order N 2920, which suspends certain requirements of the Ralph M. Brown Act. Board of Directors members will be teleconferencing into the Board of Directors meeting. If you are otherwise participate, if you're a member of the public, instructions for participating are on the agenda. And then a couple of other things. There is one agenda item that inadvertently was incomplete. It was originally item 7, resolution 2021-03 to approve formation of California Community Choice Financing Authority. And it was originally posted just for discussion, but it's actually an action item. So in order to comply with the Brown Act, we noticed a special meeting, which will happen right after this meeting. And that same agenda item is on there as the only agenda item. It's item 2. And it does in fact note that it's for discussion and action. Are there any other board announcements? I don't see any. Next item is
Chair, but I'm sorry, I was on mute.
I see
Board member Patricia Ponce has her hand raised. I think she has a question for you.
Actually, I just want to acknowledge that San Pablo's here. I was in the waiting room, got here late. Thank you. That's
Thank
all.
you.
Okay, so you're full-fledged now, right?
Yes.
Okay. Okay, so item 3 is public open time. Are there any members of the public who wish to speak on any item that is not on the agenda or is on the consent calendar?
See no raised hands.
Okay, thank you. And the next item is report from Chief Executive Officer.
Great. Good evening. I have a very brief report this evening. I wanted to start off with a warm welcome to Leela Monken, who is just sworn into our board of directors this evening. She is representing the town of Corte Madera, replacing Director Kuhnhart. So warm welcome to you, and we're excited to have you on the board. Next, I wanted to let folks know that we've just issued a really exciting program called the Flex Marketplace, which is allowing vendors that help folks shift their load to different times of day, tie in to our incentive program for payments, like direct payments that will be paid out based on how well they do at shifting demand. And this is going to come in really handy when we're experiencing peak energy events in the summertime. And we're really excited to be gearing up this program. It's been getting a lot of attention this week. The New York Times wanted to talk to us about it, as well as some local media. So you'll probably be hearing a little bit more about that. We just wanted to make sure you are aware. And then the last item I wanted to report on is SB 612. This is a bill that we've emailed you all about a couple of times. And I just wanted to provide an update because this bill is really intended to address some of the issues of the exit fee that our customers are paying when they become CCA customers. This exit fee is called the Power Charge Indifference Adjustment, or the PCIA. And we have been very active at the Public Utilities Commission, looking to correct some issues and some problems with the PCIA. For example, making sure that the corporate utilities like PG&E are selling off energy that they don't need in an economic way, so that they don't end up with stranded above market costs that our customers have to bear. Unfortunately, a decision was just issued by the CPUC, a draft decision on the PCIA, which would result in outcomes that really continue the problems of the past, the problems that we've been seeing, the problems that this bill is intended to fix. And we are definitely facing an uphill battle in the legislature with this bill. So I just wanted to encourage any of you who might have relationships with folks in the Capitol to put in phone calls, let folks know if you're supportive of this bill. And I wanted to give an opportunity for Stephanie Chen from our staff to say a quick hello. I think she's with us here. And she can help with any messaging. We have FAQs and lots of information about SB 612. Stephanie, can you raise your hand just so folks can see you? There's Stephanie. She's leading our efforts on this bill. And I should note that we are collaborating with CalCCA on this bill, and there are more than 20 co-authors because there's a lot of CCAs around the state that really support this. But we are facing some opposition from other private corporations. So with that, I will wrap up. Happy to take any questions.
Any questions for Dawn?
Yes, Director Harrop has his hand raised.
Okay.
And I think I'm unmuted. That's a very troubling development with the CPUC, and I'm sure all of us will want to do whatever we can to express our views to the legislature. Will there be any opportunities, understanding we can't meet with them in person, but by conference call or Zoom meetings or anything to actually, as opposed to just writing stuff, to make sure that they're seeing a face behind the views being expressed?
Yeah, what we've found to be most helpful is if you already have a relationship with someone in our delegation, reaching out to them directly is really helpful. And Stephanie can also help set up meetings if that's helpful. We believe many of our representatives are aware and engaged on this issue, but not all of them. So Stephanie can kind of point you in the right direction and let you know where help is needed most. But if you have, direct contact numbers of any legislators, reaching out to them by phone is really the most effective thing at this point.
Yeah, the good and the bad news for those of us here in Moran is I'm sure both of our elected representatives are fully on board with our approach. So we'll be talking to people who already understand.
Yeah, well, thank you for your support. And Director Green?
Director,
Yes, Don, can you identify the corporate opposition to SB 612?
Oh gosh, I think I'll hand it over to Stephanie to say a little bit about that. There are a number of groups that have come out in opposition. So Stephanie, do you want to comment on that?
Yeah, so far the primary written opposition has come, or the one that we're most concerned about, has come from Southern California Edison, but we also expect that the other IOUs, in particular PG&E, will probably end up opposing as well. It's just that the letters aren't due yet, so they'll probably come in on the day that they're due.
I see. So what you anticipate is the usual cast of characters.
Yeah, I think so.
Okay, thank you.
Mm-hmm.
any other questions for Dawn? Apparently not. The next item is item 5, the consent calendar. Before we get a motion on it, any members of the public want to speak on this?
See no raised hands.
Okay, is there a motion to approve the consent calendar?
Move approval of the consent calendar.
Okay, motion by Green. Is there a second?
Second.
Second by Quinto.
Mhm.
Okay, let's have a roll call vote, please.
Belvedere,
Yes.
Venetia, Concord, Corte Madera,
Yes.
County of Contra Costa County, Danville,
Aye.
El Cerrito,
Yes.
Fairfax,
Aye.
Lafayette,
Aye.
Larkspur,
Yes.
County of Marin,
Yes.
Martinez,
Yes.
Moraga, Mill Valley, Napa County and all 5 Napa cities,
Yes.
Novato,
Yes.
Oakley,
Aye.
Pinole,
Yes.
Pittsburgh,
Yes.
Pleasant Hill,
Yes.
Richmond,
Yes,
Ross, San Anselmo,
Yeah. Yes.
San Pablo,
Yes.
San Rafael,
Yes.
San Ramon,
Yes.
Sausalito,
Yes.
Solano County,
Yes.
Tiburon,
Yes.
Vallejo,
Yes.
Walnut Creek.
Yes.
Motion carries. Roll call complete.
the next item 6, is update on prepayment of certain MCE renewable energy power purchase agreements to reduce cost.
Great. And we are going to hear from Garth on this item, as well as a couple of other folks. So I'll turn it over to you, Garth, and you can introduce the others.
Yes, thank you. Sorry, when you get brought into the meeting, it goes dead for a while. It's kind of disconcerting. So I was off the screen and couldn't hear anything for a minute. So let me get things going here. All right, great, thank you. So good evening, everyone. I'm Garth Salisbury, MCE's Director of Finance and Treasurer. We have a short but focused agenda tonight on the prepayment transaction that MCE staff and consultants have been working on since early last year. So first, I'd like to recognize Mike Callahan, Senior Policy Counsel at MCE, who has been very much involved in the transaction and will be speaking to you tonight about some of it. I'd also like to introduce a few external members of the team of consultants that MCE has put together to work on the transaction, and they're also joining us tonight. First is John Norman. John, are you there? Okay, I see you there. John Norman is down in the lower right-hand side of my screen anyway. John is a managing director at Municipal Capital Markets Group based in Denver, Colorado. MCM is MCE's financial advisor on this prepayment transaction. As our FA, they assist with the negotiations of all the financial and risk terms and the documents, and we'll be doing quantitative analysis on the transaction. And importantly, will assist us during the negotiation of the pricing of the bonds to finance the prepayment. Doug Bird is also with us. Let's see if I see Doug anywhere. So I don't see him, but maybe he's coming on. Doug, you put your video on.
I'm here.
There you are. Okay, now I see him. There he is. Okay. Doug Bird is with us as well tonight. And Doug's a partner at the firm of Chapman and Cutler, based in New York. So hopefully we won't go too late tonight because it'll go well beyond Doug's bedtime. Doug is a prepay counsel to us and represents MCE in all the documents and in deal terms and negotiations with the lawyers and bankers that are on the other side of the table. And then finally, I'd like to introduce Jim Tracy. Jim is a consultant to MCE on financial matters, and particularly those related to interactions with the board. And Jim was at the Sacramento Municipal Utility District for almost 30 years and was their CFO for 13 of those years. And Importantly, SMUD did 3 prepayment transactions during his time there. And so he brings a lot of experience to the table when it comes to prepayments. Hey, could you put up the PowerPoint presentation, please? Thank you, Enyo. Oh, that's not the right one. That's coming, but that's next. So yeah, it's the other one on the prepayment update. There we go. That's it. Thank you. Okay. Okay, so let's go to the next page. Great. So on our agenda tonight, we're going to discuss the tax law and history and applicability of tax-exempt prepayment transactions in California, and specifically for an entity like MCE. We're going to discuss and give you an update on the prepayment transaction that we've been working on and the team members that we put together to work on the transaction. Then we're going to go into a high-level discussion of the transaction and how the prepay will work, and how we're going to prepay 3 of MCE's renewable power purchase agreements. Then we'll have John Norman, our financial advisor, talk about some of the risks and mitigants, and then ask for a recommended action of the board. I'd respectfully ask that we hold questions till we get through the presentation. It's very, very likely that some of your questions will be answered as we go through it, but we'll certainly give plenty of time to ask questions, get them answered, and have a discussion when we get to the end. Next slide. So it's a little history in the tax law behind municipal prepayment transactions. So municipal electric and gas utilities, and MCE is a municipal utility. But in the US, we can prepay for a supply of electricity or natural gas and from a taxable corporate entity, and we can fund that prepayment with tax-exempt municipal bonds. So prepayment transactions are legal and codified in the US tax law. So since the first prepayments were done back in the 90s, the IRS issued rules specifically allowing them. And Congress even enacted legislation in 2005 under the National Energy Policy Act, which allowed specifically gas prepayment transactions. So these are codified in the IRS rules, and is actually legislatively as well. So by last count, there's been over 90 of these transactions done, totaling over $50 billion around the US. These prepayments save utility ratepayers, whether they're natural gas or electricity from gas-fired power plants or from renewable energy. They save billions of dollars in reduced rates and energy charges, and will do so over the life of the transaction. Next slide. So this is just a snapshot. This is the 11 prepayments that certainly I'm aware of that have been done in California over the years. It totals about $5.7 billion. You'll notice that the timing of these transactions is sort of bunched into certain time periods, and that's really because of the market factors that really make these transactions attractive. So in certain interest rate environments, the transactions are more profitable or save more money. And so in those market environments, you see a lot of transactions get done. Let's switch to the next slide. So these are just 4 of those transactions, and I wanted to highlight them because SMUD did a transaction that was partially gas and partially later going to be renewable energy. MSR did a relatively large transaction. MSR is Modesto, Santa Clara, and Redding, so 3 cities that have municipal electric utilities. Some of you may recognize SCAPA, or Southern California Public Power Authority, which is a joint powers agency that represents LA Department of Water and Power, Burbank, Riverside, and some of the municipal electric utilities in Southern California. And they did 2 prepays of wind deals. So again, these prepayments for renewables have been done. There's a little bit of a different structure, but again, these transactions are popular when the market works to have them done. Next slide. So I mentioned a little bit about the team that we put together. I'm really proud of this team because I think they represent some of the best in the business. These are legal and financial consultants. As I mentioned, Chapman and Cutler is our prepayment and disclosure counsel. They work very closely, kind of hand in hand with us as we negotiate the documents and all the terms of those documents. And so Doug represents us from Chapman and Cutler, and really has a finger on the pulse of what's going on in the documents from a risk standpoint. Our bond and tax counsel is Orrick, Harrington, and Sutcliffe. Orrick is by far and away the preeminent firm providing bond and tax opinions on these transactions. And they would do it in any transaction that MCE would be doing. Also, as I mentioned, our financial advisor, Municipal Capital Markets, once again, by far and away the most experienced firm advising municipal entities and utilities on these prepayments. And finally, last but not least, Steve Hall of Hall Energy Law. Now, Hall Energy Law is our contracts counsel, does most of our contract works when we put these PPAs together. So he's very much involved with them as we talk about the necessity to assign or novate these 3 contracts to facilitate the prepayment. Next slide. So this is a very high level description of what we're proposing would happen here. So we've identified 3 renewable power purchase agreements that would be assigned or novated, as the term is, to Goldman Sachs. And Goldman Sachs is the prepaid supplier and also the underwriter of the bonds in this proposed transaction. So it's really important to realize that these power purchase agreements, the contract terms remain exactly the same as they are currently in terms of scheduling, operations, and so on, the renewable energy credits, all of those things are exactly the same. But we get this energy from these contracts now with savings or a discount of somewhere from 8 to 10% as a result of the prepayment. Also, to kind of put it in perspective, these 3 PPAs represent less than 8% of our energy costs each year. So as you're probably aware, MCE literally has billions of dollars of notional amount of contracts, long-term, intermediate term, short-term. These represent 3 of the longer-term renewable contracts that we have. But again, it's a small percentage of our entire portfolio. Okay. The tax-exempt bonds that would be issued, they wouldn't be issued by MCE. They would be issued by a tax-exempt conduit. A couple of reasons for that. But specifically about the conduit, we first considered utilizing a very commonly used conduit called the California Statewide Communities Development Authority. They have literally thousands of bond issues done on behalf of guarantors and other issuers. But they were very expensive in what we were quoted in terms of the cost to utilize them to issue the bond. So what we're proposing, and what we'll talk about a little later, is creating a CCA-specific conduit, or JPA, to issue the bond. So that's proposed to be the California Community Choice Financing Authority, CCCFA, much, much cheaper than utilizing the existing conduit, and with some other advantages as well. But again, we'll talk about that actually at the special meeting following this one. So if there's anything you take away from tonight's discussion, I think this is the most important one. It's that the bonds are issued, they finance the prepayment, which goes to the prepaid supplier, which is Goldman Sachs. It also finances the issuance cost and the reserves. The bonds are not the debt of MCE. The bonds are secured by Goldman Sachs because they have received this large prepayment up front. So they get the lion's share of the proceeds. As a consequence, they're the ones who ultimately are securing the bonds. And the bonds actually carry their ratings, the A2 and Fitch A rating of Goldman Sachs. So again, really want to emphasize that these bonds are not a debt of MCE. They are in fact secured by Goldman Sachs, and so dramatically reduces the risk of participating in this prepayment transaction. I'm going to hand it over to Mike Callahan right now to go over the next slide and talk about some of the other transaction terms.
Thank you, Garth. I'm going to cover briefly some of the sample of the transaction terms we'll be working with our deal. So the conduit issuer, CCCFA, will be selling all the power it receives from the novated PPAs from Goldman to MCE under a clean energy purchase contract. That's sort of the primary vehicle for this deal and how MCE will be receiving all the energy. And that'll be set up for an initial term of 5 to 10 years at a fixed discount. And it's going to be a discount, again, as Garth said, to the current contract prices that we'll be prepaying. After the term expires, there'll be a reset period where we look to see if a minimum discount is available. If it is, the deal will continue to roll over. And if not, we'll have an option to bring the deal down. If the savings are available, the deal could continue to roll over for up to 30 years. That's the term of the clean energy purchase contract, but it may terminate early for various reasons. MCE may also novate additional power purchase agreements beyond the 3 that we've already identified. If any of those 3 expire or stops generating for any reason, to keep the deal whole. And the minimum savings we're aiming for in this deal is an 8 to 10% discount on the original contract price for the initial reset period. And the savings are generated for these prepays by looking at the difference between the taxable borrowing rate, that would be Goldman's borrowing rate, versus the rate that you could get in the tax exempt bond market. And so there's a benefit for both Goldman and MCE in that spread. The next slide, covering risks and mitigants, will be covered by John Norman.
Thank you, and it's a pleasure to be here this evening. I hope my audio is coming through and video. I'm going to be a little bit redundant and touch on some of the things, points that have already been made, but perhaps in a slightly different context. Since the first prepays in the early 1990s, we've structured these transactions to do a couple of things. First of all, retain the accounting treatment consistent with other commodity purchases. That is, as
Hey, would the person with the dogs mute your microphone, please? Thank you. Go ahead.
That is, first of all, to retain the accounting treatment consistent with other commodity purchases. That is an operating expense for the purchase of a commodity where the end user only pays for that which it receives. And second of all, if there is a failure or termination of the prepay, then the end user suffers only the loss of the discount associated with the prepayment and goes back to making the commodity purchases as they did before. And in this case, that means the PPAs would revert to MCE, and that's a recurring theme that you're going to hear me touch on over and over again. To do these two things, we do a couple of things. They've already been touched upon. That is, we use a conduit issuer to incur the debt and enter into the prepayment rather than the end user issuing the debt, which would just be a mess. That conduit issuer then sells the commodity to MCE under the aforementioned clean energy purchase contract, where MCE's periodic payments are due only in arrears of delivery. And thereby we retain the accounting treatment as an operating expense of the end user, MCE. The second tool is relative to the security for the bonds issued by CCFA, and Garth has made this point. All credit roads lead back to the prepaid supplier. They after all have all of the cash. The credit rating is therefore that of the prepaid supplier. And by the way, the cast of institutional investors that tend to be the buyers of the prepaid bonds understand exactly what they own. They're the same buyers from transaction to transaction. If the transaction terminates, then the prepaid supplier is required to make a termination payment that's sufficient to redeem the bonds. This insulates our municipal issuer, the CCCFA, and further insulates MCE from exposure on the bonds. So these 2 points are approaches to prepay structuring underpin most of the risks and mitigants on this page. So the first 3 of these listed risks, program terminates early, prepaid supplier fails to deliver energy, the prepaid supplier becomes insolvent, are mitigated in the same way. The PPAs return to MCE under the original terms, of course, no discount. The bond repayment is provided through either a Goldman Sachs termination payment to the trustee used to redeem the bonds, or upon the bankruptcy of Goldman Sachs, it's addressed in the bankruptcy proceedings. By the way, the failure, the second of these bullet points, the failure of Goldman Sachs to deliver is only as likely as the PPA's seller's failure to deliver, and this is on a chronic basis. This is common in gas transactions. We have it here. It's not very likely at all to ever happen. Goldman Sachs is only in the line of title, what we call flash title, but really has no control over the PPA supply. The next bullet point, in the event that MCE needs for electricity are significantly reduced, then the prepaid supplier resells the energy to another tax exempt entity. And if they can't, the deal is unwound, bonds are retired, and the PPAs returned to MCE under the original terms. Of course, no discount. If there are problems with MCE's retention of the renewable attributes, then again, recurring theme, the PPAs return to MCE, no more discount. And if the savings are less than the guaranteed minimum at a bond reset, then MCE has the option, of course, to purchase at the lower discount. It can sit out for that reset period with the PPA supply again reverting to MCE and Goldman Sachs selling power into the market. Or the transaction could be terminated, and again, the PPAs would revert to MCE. The last two bullet points, bankruptcy of another CCFA member or default of another CCFA transaction by another member, does not affect MCE's prepayment at all. All of the assets, revenues, et cetera, are held in trust for the benefit of the bondholders. And likewise, no subsequent prepayment by MCE is commingled with any other. Thank you, Garth.
Great, thank you, John. So before we talk about a requested action, I appreciate everyone sort of holding off your questions. So we want to open it for questions now. I also wanted to remind you that, in addition to John, Doug Bird is also on the line and available. So if a question comes up, I may direct it to Doug and also Jim Tracy as well, who again was at a municipal utility who has done prepay. So we've got a pretty good team of people here to answer any questions that might come up.
Director Barbara, you have a question?
Controller.
Yes, thank you very much for the presentation. I have a couple of questions that maybe I'm just confused, but when you talked about Goldman Sachs potentially going insolvent, and then it talks about bonds repayment happening through bankruptcy proceedings, to me that sounds pretty risky because that's a pre-petition for bankruptcy, which could be completely wiped out by a bankruptcy court. So, I mean, I've worked on a lot of bankruptcies and other avenues, and there is no certainty with bankruptcy proceedings, but because those debts would be prior to a bankruptcy, I'm not sure how we're so confident that that would be handled by a bankruptcy proceeding. I think we would be potentially stuck sort of holding the bag there. And then the other question I have that sort of relates to bankruptcy was on that same slide, you had two bullets that talked about if a member of CCCFA, I believe that's the acronym, goes insolvent or goes bankrupt, that it, again, it didn't seem like there was a risk for MCE, but my question is, what if we're entering into a, and maybe that I'm wrong, what if we're entering into a prepayment with another CCA or two, and one of those goes bankrupt? Aren't we still in a pretty risky situation there? Because I think we would be left having to pay that off. So it may be that it's my ignorance, not totally understanding this. And then I just have a quick question on the agreement itself, and I can hold that till later. It's just a detailed question.
Okay, good. Thank you, Director Kohler. So I am going to direct these questions to Doug. I think probably the most appropriate person here, on our team to answer those. And so the first one was, hey, if for example Goldman Sachs goes under, wouldn't it be possible the bankruptcy judge determines that MCE is responsible for that debt? I think that's what
okay, remember in a bankruptcy, there's something called pre-petition. So if Goldman Sachs went bankrupt on X date and all our transactions were before that date, you have to stand in line with all the creditors to get in line. And if you're lucky, you may get 1 cent on a dollar. So
Yeah, that's correct.
it's,
Yeah, so if we can just, let me just address that question first. So,
Sorry to interrupt. Can you clear the screen, the presentation, because it's hard to see everybody?
Sure.
yeah, but,
Yeah.
so in the bankruptcy of Goldman Sachs, right, the obligation, the prepayment transaction terminates and Goldman is obligated to make a liquidation payment. That's an agreed upon amount that is sufficient, which is confirmed with the rating agencies, part of their structure rating on bonds, and part of their assignment of Goldman's rating to the bonds, is that that liquidation payment will be sufficient to pay the bondholders. Okay, so in a bankruptcy proceeding of Goldman, and there will be opinions from Goldman's counsel at the closing, that liquidation, and given frankly for the benefit of the bondholders as well as MCE and other transaction participants, but that liquidation payment is senior unsecured indebtedness of Goldman. And in fact, it will be subject to the resolution stay proceedings, which apply to financial institutions since, you know, the financial crisis and changes around how large financial institutions, you know, insolvency is resolved, which is frankly outside of the bankruptcy code. But nevertheless, all of those risks are risks that the bondholders take, right? Because their repayment is dependent upon Goldman repaying. MCE's only payment obligations in the transaction and only obligations, your obligation is to pay for the electricity as it's delivered to you. And it'll be delivered to you at a discounted price. So there's no obligation to make, those payments will secure the debt, but there's no obligation to repay the debt. The only obligation is to take that energy. So Goldman's bankruptcy won't affect MCE at all.
so, okay, so what you're saying is the bondholders are the ones who would be
Yes,
standing
ma'am.
in line trying to get
That's right.
where-
Yeah, and that risk is well understood, which I think Garth mentioned, or John, I guess maybe mentioned just briefly when he was going through the risks and the mitigants, is that all of those risks are well understood by the, frankly, all institutional investors that buy this debt.
Okay, and then can you answer the other question, and perhaps it's my ignorance, about if two CCAs entered into a prepayment under this jurisdiction and one of them went bankrupt, how would that work?
Yeah,
Because
so
remember, bankruptcy court does not follow any rules.
yeah,
They
no,
do
that's
their own
good.
rules.
Yeah, completely understood. Life would be a lot easier if that weren't the case, but clearly understood. But the contract that you have or the other CCA would have is a contract for the sale of goods, right? It's actually governed by the UCC. It's an Article 2 sale of goods contract, and there's payment in arrears. So it's payment for commodity delivered in the preceding month. There is an event of default, for example, in your clean energy purchase contract. If MCE were to go bankrupt, that contract terminates. And in that instance, Goldman Sachs would be obligated to find another municipal utility to buy that power, right? And you would still be on the hook for the power that you took and didn't pay for, but it's like a rent on your apartment. You go bankrupt, you're not held liable for the remainder of your lease, right? It's an executory contract, sale of goods. That contract goes away. You're liable for the commodity you took and didn't pay for, but that contract is now over.
But if there's two CCAs joining in to buy one prepayment and one of them goes bankrupt, and let's say MCE is the one who doesn't, you're saying that it's like if you're renting an apartment and you have two people there, you only have to pay your part of the rent?
Correct. And Goldman then picks up that, they then take that commodity. They're still obligated to continue to deliver the commodity to the Joint Powers Authority, the CCCFA, right? But that
Okay.
power now doesn't have an off-taker because one CCA has gone bankrupt. So Goldman finds a new off-taker, or Goldman decides that they can't find an off-taker, and so they terminate, they downsize the deliveries and pay a partial liquidation payment. And that part of the transaction goes away, and the non-bankrupt CCA continues without any change to your existing.
Thanks
rate.
for your patience answering my questions.
Okay, you're welcome.
Director McEntee, nice to see you back. I think you're muted. You're muted. Or your microphone's not working, I think.
Okay, can you hear me
There
now?
you go.
Hold on. My apologies, everyone. Yeah, my headphones weren't plugged in properly. Nice to see you all. I'm just popping in between our delegations. We had delegated to Ray when he was on the council, and I think we were going to be delegating to Belvedere, but it hasn't gone through yet. So I'm wanting to fill in the gap here. I'm going to start with a number of compliments and then move on to concerns. But I do want to compliment staff on a really clear and excellent staff report, which allowed me, who haven't been on this board in a while, to just jump in and really understand what's going on. So I want to compliment you on that, and I definitely want to compliment you on your innovative thinking, and you're willing to kind of not to follow the prescribed path and to think about creative ways to do things, which I always appreciate. And as always, the team is solid and has done their homework, so I don't have any concerns about that. But I have some concerns about the sort of fundamental principle upon which this is based. I'm concerned that this might go the way that purchasing Rex went for us. As those of you who have been on the board much longer than I was recall, there was a period of time early in MCE's history where part of the portfolio was renewable energy certificates, and which not everybody is fond of, and that dogged us for a long time after it was even a significant thing. This transaction is it's an arbitrage using our tax exempt status to get us a discount, but the our partner on the transaction is really not adding any value that goes along to our mission. This is just kind of it's a purely rent seeking transaction. So, and an indication of the rent seeking is how many firms are going to be benefiting from this transaction in order to save us a few dollars. So I think that as an organization, we came together around a really serious mission of that is the reason that our customers are a part of this organization. Otherwise, they would just go with PG&E, and that they're doing this because MCE's mission was to make the electrons on the grid be net greener than they were before we started, which for the most part has been true, and that is solidly to MCE's credit. And I give Don a lot of credit for that, and the staff a lot of credit for that. PG&E has turned a lot due to MCE, and MCE has led in a lot in so many ways here. So there's a lot of value that's been built up here, and people are coming to MCE for that value and for that mission. And this is something that saves us money, but it doesn't add value or create value that goes with this mission. So that to me is a not insignificant concern that I think that we should all be thinking about. Like I said, I appreciate the creativity, I appreciate the thoughtfulness, the conscientiousness of everybody, but that it's the principle of it that I think that we as a board should really give some thought to. So that's a concern that I have. I don't know whether there's anything staff would want to add about that, but that's what I wanted to bring up.
I'll make a quick comment, Sashi, and it's so great to have you back. Thanks for popping in, and great to have your historical perspective on this as well. Because you brought up unbundled renewable energy credits, I just wanted to make a comment that I can understand that the concern because certainly that was an issue that that did come up for us over a couple of years, and I just wanted to comment that we've actually seen sort of the opposite treatment with this type of financial tool, and the comments that we've gotten from folks in the community and in the energy sector is just that this is a very common tool that particularly municipal utilities have used for years, historically, to save money for their customers and to use those funds. Typically municipal utilities are, they might use energy savings for other needs in their community, schools or filling potholes or things like that. For us, obviously, the savings that we could achieve would be to deepen our impact through programs in the community, maybe getting more batteries into our low-income units or critical facilities, maybe using the savings to bring our rates down, make rates more competitive. Those are those sorts of things we can do through this type of financial arrangement. And we certainly haven't seen the types of concerns raised that you mentioned with RECs, which really are unbundled RECs, which really stem from a sense of building renewable energy, and making sure that new renewable energy is getting built for all the purchases that we make. So it's definitely a different issue. I can see how there could be some parallels looking at it from a certain angle. But I think really the question, and this will be the question for the board, really, it's certainly not for staff to decide or to move in any particular direction. This is definitely a policy decision. But I think the question before you all, after we've gotten through all of the discussion is this an opportunity that we should be utilizing on behalf of our customers to deepen our mission, to use the savings to deepen our mission, or not? Are there reasons to not move forward? And there could be, I think we've looked at the risks pretty carefully. That's certainly an area where it's important to look carefully. I think the perception is another area that you brought up, Sashi. So the question is, do those potential concerns outweigh the tangible benefits? And as far as the staff exploration that's been done over the last year plus, I think we've been looking at this over a year with board input and committee input. At this point, we have not found any perception issues or financial or legal risk issues or even compliance issues that would be a reason, a speed bump on moving forward on this. But obviously we want to make sure we're looking under every rock and exploring any potential concerns that might be coming our way. So really appreciate the input, and I just wanted to give a little response on that.
Don, I appreciate that very much. And Sashi, I mean, it isn't a number of other CCAs are working on transactions as well. So, this is, we do, and we would expect that if MCE, we're probably the furthest along on this, but we do know that at least 2, if not 3 other CCAs are actively working on transactions. So, it was just sort of a matter of time before it was figured out how to do these prepays and again, these prepays are specifically to reduce the cost for projects that MCE, as a result of MCE signing those contracts, these renewable projects were built. And so we're now just trying to reduce the cost of that, those embedded costs that we're going to have to pay for those solar projects over the life of the project. So again, it was a new project built because MCE signed the contract. We're locked into that cost. And quite frankly, some of those costs are high because they were signed a couple of years ago and contract costs, solar costs have come down. So this is a way to really help bring that cost down. And I also want to turn it over to Jim. I don't know if you have some comments, Jim. You were the CFO at SMUD where you did prepays and, did obviously SMUD is kind of out, also pretty out there in front in terms of renewables and so on. So just curious if you ever got any pushback at all from your participation in prepays.
Garth, no, we really didn't. I think the view that we took was every dollar that we could save in financing costs or other costs was another dollar in cash flow that would allow SMUD to embark on other capital projects for the customers. And, we, as I said, I think our board looked very favorably on these kinds of deals and to basically keep our rates in line with the competition, which was the investor-owned utilities in the area. And indeed, it has allowed SMUD, I know that they just issued their new resource plan, and that resource plan is to get to zero carbon by 2030. And part of the reason, they can say that they're going to embark on that is because they're very careful about these contracts they've entered into, and they actually increased their rate margin against other utilities in the state over a 15-year period. And that gave them more room to look at the borrowing program that would be necessary to build the storage, battery storage, and do some of the demand management programs and other things that they will have to do to transform that utility.
Okay, Director Rice, you're next.
Yeah, thank you. And I appreciate the presentation as well. And I think my query goes sort of along the lines of where Director McEntee's were, but I think I'll be a much less sophisticated ask. I can see from my take how appealing these prepayment transactions would be to MCE and to our agency. I mean, the financial benefit seems fairly obvious, and it really looks like it's very low risk, frankly. So I guess so MCE saves money, or the municipality that's entering into one of these transactions, but it's at a cost to whom or to what entity? And I guess I would marry that up with this is a financial tool that benefits a municipal customer, but I can't figure out who loses because of having this tool available to a municipality. And it ends up becoming an ethical question, I guess.
I mean, well, I would say, Director Rice, that we're a municipal entity. We can issue tax exempt debt. There's been literally, probably $2 trillion worth of tax exempt debt issued by cities, counties, and whoever else can issue the debt. We are allowed to do that. And so it is tax exempt. The investor does not pay taxes on the interest on that debt. And this is just a way for MCE to utilize that exemption to reduce the cost. Now, we could have bought these projects outright, issued debt to do it. And if we did, it would be tax exempt debt, right? So, so we're using that tax exemption. I mean, it's been asked, oh, does that mean that, hey, for example, the prepaid supplier, in this case, Goldman Sachs, are they getting tax exempt financing? And the answer to that is no, they're not getting tax exempt financing. What they're getting financing at their taxable rate, but it's able to be financed through MCE at a tax exempt rate. And the lion's share of that savings, that differential, goes to MCE in the form of the savings we get through the PPA. So now there are fees involved. There's no question. There are fees involved with putting the transaction together. Those are all disclosed. Again, we have our financial advisors will know exactly what is being made by Goldman Sachs and the other participants in the transaction. And MCE garners by far and away most of the benefit of the transaction through the reduction in the PPA cost. So, I mean, it is, it is clearly a little bit of financial engineering, but it is absolutely something that we can do. It's legal. And, there is sort of no real losers in these transactions. Admittedly, the bank that does it, earns fees. We know what those fees are. But again, by far and away, the beneficiary is MCE and its ratepayers.
If I could add just one thing to that answer from a little bit of a less of a financial expert brain, kind of the way that I have come to really understand this is that the value that we're capturing here is the long-term commitment that we've made to buy power. We're going to be buying power from these projects for 20 years. And that has value. That is a valuable commodity in and of itself. We know we're going to be paying for the power as it's delivered for 20 years. And so we're able to kind of monetize the fact that that's a consistent revenue stream. And we're able to monetize the fact that we are a tax exempt government agency, which is designed, just the way that our the rules, the tax laws are set up in our country are for local government agencies to be tax exempt and private corporations pay taxes. And so we really aren't capturing the value that's already there for us under the current structure.
Director Thier.
Thank you.
Thank you so much. I want to thank staff. I want to thank Director Salisbury, Mr. Callahan, and consultants Norman and Berg for what I think was an excellent presentation. I see this issue a little differently, and I see the MCE board as having a duty to its ratepayers. And I believe that what we can do to save money and save cost for our ratepayers is something that we really need to do. I don't see a downside to this at all. That we will be paying some cost to consultants, but they will help us save that money for the ratepayers. Entering into the contracts for 20 years also is an advantage, because if my understanding is correct, and I'm going to ask the experts here to correct me, we're getting the benefit of that rate. In addition, it's a long-term deal, so we know who we're dealing with. I also think that, we've seen the presentation cites that there's 90 different municipal prepayment transactions that have already happened, and that has resulted in billions of dollars in reduced rates and energy charges. And I tell you, as a consumer, I wish I could do this. I wish I could prepay for energy. I think this is fantastic. I think it's a benefit to our ratepayers, and I think it's perfectly in line with MCE's values. So this is something that I'm very much going to support. And thank you.
Director Harrell.
Thanks, Tom. Am I on? I think I am. And thanks, Holly, for those comments. I feel like anything that I would say now would just simply be piling on. I agree with all the comments that Don and Garth and Jim have shared, and very much support this. I personally have been involved in conversations where this has been teed up over the last year, and feel very confident that this is something that will be of great benefit to this organization. And just to provide context, because I know the issue of some of the past concerns with policies involving RECs were highlighted. This is nothing like that. The way in which MCE utilized RECs earlier on, because I don't think we're doing any of it anymore, but earlier on in its history was an opportunity to make a distinction between us and some other CCAs that didn't necessarily work to our favor. and it had to do with substantive issues concerning the way in which we conducted our business. This is nothing like that. This is purely an opportunity to create cost savings for our organization, for our customers, and for those who benefit from the programs that we put together. And more importantly, unlike the issue with, or the situation with the RECs, we are in line, I think, with the overwhelming thrust of financing that similar organizations are pursuing throughout the state of California. So we are in the middle on this one. We are not an outlier, and I really hope that the outcome of this conversation tonight will be to adopt the recommendation of staff and direct the finalization of negotiations and bring this back to the board for final approval at the appropriate time.
Director Fong.
Yeah, thank you. And again, my questions are going to be from the perspective of being kind of a layperson listening to this conversation. I first want to thank everyone for the presentation. Very persuasive, and it makes good sense. But I want to kind of get a quantifiable understanding of what we're talking about here. First question is from I'll call it a risk sensitivity range, risk reward sensitivity range, from low risk, which is 1 to 10, which is high risk. How would you rate what we're with this prepayment initiative? Low risk, medium risk, high risk, and be able to quantify that.
Okay, I'm going to turn that one to John Norman, our financial advisor. Again, he's been involved with these transactions for pushing on 30 years. And as they've evolved, and they've evolved in a way such that there's less and less risk to the off-taker, in this case, MCE. So John, I'll have you answer that question and that scale of 1 to 10 question as well.
Sure, thank you. Appreciate the question. One of the most difficult things in dealing with these transactions is convincing people that there is no risk. I would rate it as a 1. It's a real win-win-win. The risk to MCE is virtually non-existent.
Okay. And then the second question is from a forecast perspective, as we take a look at the savings and in your modeling, what and as you forecast for, say, the next 5 years, what's the realized savings that you believe that you'll be able to achieve?
Yeah, that's a very good question. I think we are targeting somewhere around $3 to $3.5 million a year on these 3 PPAs. Again, the cost for these, the amount, these are 3 solar projects that we're talking about here that these PPAs represent. The annual cost for the energy from these 3 projects that MCE pays is somewhere between $30 and $35 million. And so we hope and expect to save around 8 to 10% on that. And then every year going out for as long as, the transaction is in place. Okay. And, if we're successful with this and if it works, and it happens and we start saving money, I mean, as I mentioned, this represents about 8 to 10% of our total portfolio. And we'd want to do this, with other contracts, right? And right. Continue to do this. And you see this with some utilities, particularly in the Southeast. They have prepaid almost all of their, whatever it is, if they're a gas utility, they've prepaid everything because you just do that because you want to save the money. So, so that gives you a little perspective on what we're talking about with this particular transaction. Okay. But again, if we're successful, we'll probably want to come back and do some more.
Perfect. And then final question I have is, from these savings, have you done any type of, I'll call it return on investment modeling on how those savings are going to be allocated or invested in projects and which projects they are, and any perspective on returns for a return on investment on those specific projects? Or is that a little bit too deep and into the detail and you haven't gone that far yet?
Yes, a simple answer to that is no, we haven't gone that far yet. I mean, it's really about just trying to determine what the dollar savings would be. MCE is involved in lots of programs, our battery storage program, other types of programs where we could reinvest those savings. But right now we're simply looking at it on the basis of, what are the savings? What does it represent? And what does it really, quite frankly, do to our bottom line, which then again with that, from that bottom line, we do the investment in our other programs.
Yeah, fair. And again, once we realize those savings, we can talk about, how to reinvest back into the initiatives that we need to work on. So thank you very much.
Yep.
Great answers.
Yep.
Director Wilkinson.
Hi, thank you. So firstly, I've spent quite a bit of time going through the details of this transaction with Garth, or this JPA with Garth and Vicken. And I tend to agree that the risks, the direct financial risks associated with the transaction seem to be, I wouldn't say zero, but relatively limited. The bigger issue that I have with these transactions is that the IRS, in broad terms, has something called an economic substance doctrine, which in typical terms means that if a business is going to do a tax transaction, it has to also have economic substance and a business purpose. Otherwise, it's viewed as an abusive tax transaction. I realize that this specific carve out has been given in relation to natural gas, and that seems to mean that that will also apply to clean energy as well. But I just want to sort of step back and sort of talk about what that actually means from the perspective of MCE. So what these transactions, as I understand, and Garth, correct me if I'm wrong, but what these transactions will do essentially is allow Goldman Sachs to utilize MCEs or the JPA's tax exempt status to issue tax exempt bonds, and that generates a saving, which is money lost to the IRS. The IRS is the loser in this. There is always a loser. And so that money is then split between Goldman Sachs and MCE. So the issue I have with that is that MCE, which is a brand with a stellar reputation and everything to lose, is going to be going into seeking activities that are just looking to make short-term money. And we're talking about $2 million on a business which has $600 million of revenue a year. And to me, the risk here is not the direct financial risk, it's reputational risk. And so what you're seeing is, again, a public agency enabling a private firm to issue tax-free debt and sharing the spoils of that transaction. And I think for MCE, which has branding around clean energy and being a good public agency that has risks in terms of what it will mean, not to people who might be interested in buying this bond, but to customers. MCE's customers who've opted out of PG&E to move to MCE, which is actually a more expensive company to buy energy from. I feel that there'll be people who will say, why will I continue to do that when I can get clean energy now from PG&E? Why will I do that when they are entering into tax schemes, which are nothing more than tax schemes, to take money from the IRS and share it with a financial institution? And so I've gone back and forth on this so much, but I had a long conversation with Belvedere's mayor and with a former council member who served on MCE. And the way that that former board member sort of phrased it to me or made me think about it was to say, if a financial institution or taxable entity came to the city of Belvedere and said, tax exempt status to issue some debt and we'll give you a kickback, does that work for you? We would say no. There's no way that we would do that transaction. So I understand there's been a ton of work gone into this. I know transactions are done by other companies, but from my perspective, for a public agency that has a brand around public good, I just can't see, with the small amount of revenues that will be generated from these transactions within the scope of MCE's overall operations, that it is a wise thing for MCE to be doing.
Go ahead, Garth.
No, I mean, if there's anyone on the board that certainly that cares to respond to that, I would certainly encourage them to do that.
Director Thayer.
Oh, I have my hand up.
Sure. I just wanted to say that in response to Director Wilkinson's comments, I kind of understand what you're saying, But I do think that this is a priority that was set in the tax code. So this is a way for municipalities or for renewable energy or for entities that buy public power. We're not stealing money from the IRS. This is a priority that was set forth in legislation. I believe it's a tax code section. I can look it up. It was in the report. But this is a priority so that this organization, an organization that is providing cleaner, greener energy, can reduce that cost to its ratepayers. So I don't think we're doing anything odd here. I don't think we're doing anything that is not above the board. If we were, I wouldn't support it. But I do think this is a way to decrease the cost long-term to our ratepayers. Again, I feel very strongly that as a board, we are the fiscal authority over our ratepayers. We have to do what we can do to save money. And that is the bottom line. We are an organization that provides energy, and we have a duty to provide it at the lowest cost possible. I really believe that these types of projects that Director Salisbury's brought and our entire staff, this is exactly the kind of projects and things that we should be looking at in order to move the organization forward, in order to take the money that we're saving and put it into something else that benefits the organization. But I don't believe that we're actually, these priorities were set up just for this purpose, just to allow this agency to save the money. So I'm still going to support this, and I don't believe there's anything not above board that we're doing here. So that's it.
Director Perkins.
Yes, thank you. There is nothing immoral. There's nothing unethical. There is nothing that skirts the edge of the law in doing this. And if this generates $2, $3, $4, $5 million a year in additional revenue, or reduced costs, I should say, it doesn't actually generate revenue, it just reduces costs. That gives us opportunities to do additional projects for communities that need the help, for electric vehicle projects, for financing additional solar projects and other beneficial things. The federal government, through Congress and the IRS, have established these opportunities. And frankly, I think we would be, it would be against our code of ethics to not take advantage of them when they are offered. Thank you.
Director Meisner.
Thank you. So I guess the term loser made me think of, so who are the losers? And I think that point has been made. The taxing entities are the losers. And I think about these various bond mechanisms, and one of the things that actually hurts our city, I mean, it helps our citizens, but it hurts our tax base, are the low-income housing bonds. And that tax exempt, what happens is the bond holders don't have to pay local property tax. And that's really challenging for us, because usually generally some of those projects tend to use more services, but they pay less taxes. And so that's what I was thinking of when I was thinking of losers, are the taxing entities. Here, this is federal income. It's similar to the opportunity zones that were created a couple of years ago that we're trying to take advantage of now. And giving somebody the opportunity to pay less federal taxes is giving us the ability to attract investors. And so, it's definitely something to consider. But I think in the end, I would prefer that we go forward with this to give those people that don't have, that may need the benefits of MCE that normally, or just some of the programs that MCE offers. that they might not be able to get otherwise. And so I think that's really important. I would actually hope that the savings that we receive would actually be directed towards those low-income people. I think that would help sell it, frankly. Thank you.
Director Darling.
When I first looked at this through the executive committee, I went and looked for examples, and it turns out it's a very common practice for municipalities to do this, only with the kind of greenhouse gas creating problems. Natural gas is the most obvious one that's used on. So I kind of regard this as what's good for the goose is good for the gander. If we can find a way to help save money for our ratepayers and still recognize the greenhouse gas reductions, then I'm willing to save the money, especially since the federal government has said this is okay. It is a legitimate use of our tax exemption. So I'm willing to support it.
Director Vasquez. Unmute, please.
Sorry, I didn't catch the last part of Cindy's comments. Did you move the item?
I'm about to, but not yet. I want to give everybody a chance to speak on it. Did you want to speak on it, or you want?
Yeah, I don't know anybody that doesn't take advantage of a tax break or tax credit. It's, I mean, we didn't write the laws. This is an opportunity for this public entity to take advantage. I won't say take advantage, but make use of the laws that's in place. As a county supervisor, we've done these kinds of things in the past, securitized our master settlement with the tobacco money so that we could use those revenues quickly to do some really good projects. I see nothing wrong in this. And so I'd like to move it. I think we've had enough discussion on it.
Well, I'm inclined to ask that we move it too, but I need to call for public speakers first.
Oh, okay. Sorry.
Two other people are signed up, but both of you have already spoken. We're kind of getting redundant here. So,
Tom, could I just ask the basic question that I didn't ask when I first? It was just a general question.
Go ahead. Let's wrap this up.
Okay, just a question. In reading the JPA agreement, I noticed we talk about appointing a general manager and then some other staff if necessary. And my only question is, we're saving on each transaction roughly $250,000, I think, from basically what I read. Are we going to end up forming this new JPA that would have quite a lot of staff that would cost us additional? Because I know we went to the JPA model because we wanted to save money from working with this other entity. And so it's really just a general question. And I think Garth has the answer. I just wanted to make sure that we weren't creating a new entity that would cost us a lot of money.
Yes, Director Cole, it's a good and legitimate question, but no, that is not the intent. We will be addressing the JPA in the special meeting next.
Okay.
Probably more appropriate to ask the question there, but there's no intent to have staff and paying staff with the prepayment conduit that's being set up. So there's no necessity for it. I mean, the JPA law generally allows it, but that's not the intent or expectation at all with the conduit JPA set up to do these prepays.
Okay, just because I saw there was a couple of sections that talked about that. So it's basically just covering the bases sort of thing?
Yes, absolutely. And again, there'll be a lot of opportunity to talk about that more when we bring the JPA.
Thank you.
Do you mind if I just ask one?
Director Butt.
What?
Director Athos has had her hand raised for quite some time.
I don't even see her. Where is she?
There she is.
Okay.
I know I'm short, but I'm not so short.
All right, let's go. Maybe she's on the second page or something. Go ahead.
Actually, I think my question is for the next section after all of that, but I appreciate that, Darlene. So I'll hold my question until we discuss because it's regarding sections.
Okay, Director Wilkinson, in the interest of wrapping this up, you have something else you want to add?
Yeah, given that you have all these finance people in the room, I'd love to ask just one specific question in terms of risk, which I wanted to clarify for my own understanding. in the circumstance that the JPA is formed and most of the CCAs go bankrupt, which isn't impossible within the JPA, there are less than 3 CCAs left in the JPA, what happens to the debt that's currently off balance sheet? What happens to the debt?
Doug, do you want to answer that? I mean, nothing happens. I mean, the JPA always must remain in existence, and the debt remains outstanding. The potential negative effects to MCE, if there are less than 3 what are known as founding JPA members, is that there could be some different treatment of the debt for accounting purposes, but not in terms of liability or the necessity to repay the debt or anything else. So it is more of an accounting issue about how it's treated as opposed to any other detrimental effect from a financial standpoint. But again, that's another thing. We will again address that specifically at the JPA item, Director Wilkinson.
Okay, do we have any public speakers?
I do not see any raised hands, Chair Butt.
Okay, I would entertain a motion now.
Okay, I would like to move that we direct MCE staff to complete negotiations and documentations and come back to the board for approval of all transaction documents in near final form and adoption of a parameters resolution allowing MCE staff to execute documents if and when certain minimum savings are met.
Okay, is there a second?
Second. Perkins.
Okay, motion by Thier, second by Perkins. Let's do a roll call vote, please.
Belvedere,
No.
Benicia, Concord,
Yes.
Contra Costa County, Corte Madera,
Yes.
Danville,
Yes.
El Cerrito,
Yes.
Fairfax,
Yes.
Lafayette,
Yes.
Larkspur,
Enthusiastically, yes.
County of Marin,
Yes.
Martinez,
Yes.
Moraga, Mill Valley,
No.
County of Napa and all 5 Napa cities,
Yes.
Novato,
Yes.
Oakley,
Yes.
Pinole,
Yes.
Pittsburgh,
Yes.
Pleasant Hill,
Yes.
Richmond,
Yes.
Ross, San Anselmo,
Yes.
San Pablo,
Yes.
San Rafael, San Ramon,
Yes.
Sausalito,
Yes.
Solano County,
Yes.
Tiburon,
Yes.
Vallejo,
Yes.
Walnut Creek.
Yes.
Motion carries. Roll call complete.
Okay, the final item is board matters and staff matters. Are there any other items anybody wishes to bring up at this time? Any members of the public?
Can I bring up one thing?
I see Director Murphy with a hand up.
Yes.
Oop, I see several hands up, but go ahead, Director Murphy.
Thank you, Chair. I just wanted to thank everybody for the conversation tonight. I thought it was very informative. I know there was some disagreement, but I personally thought it was very informative. And just wanted to thank everybody for being so engaged. I also just wanted to thank the staff and certainly wanted to thank Don. The staff will be presenting at the City of Pinol's meeting this Tuesday. And we're really excited, especially with so many things we've done over this board has done over the last several months. both city residents, but also our city staff and our council are very excited to have you. So if no one else has a meeting on Tuesday, I say that very sarcastically because I think pretty much everybody on this call has a meeting on Tuesday. Feel free to chime in and join us. But I just wanted to again thank you all for thank MCE staff for making that a priority and coming to our town virtually, of course. But thanks again.
Director Thier.
Yes, I just wanted to let everyone know that I'm very proud of the town of Tiburon. We just passed a climate emergency resolution. So I just wanted everybody to know that. And I'm proud of our town.
Okay, anyone else? Okay, this meeting is adjourned, but don't go away. We will move into our special meeting. So we will convene it. This is a special meeting of the Board of Directors. And we're going to have to call the roll again. So go ahead, Darlene.
Okay. Belvedere.
Yep.
Benicia. Concord.
Here.
Contra Costa County. Corte Madera.
Present.
Danville.
Here.
El Cerrito.
Here.
Fairfax.
Here.
Lafayette.
Here.
Larkspur.
Here.
County of Marin.
Here.
Martinez.
Here.
Moraga. Mill Valley.
Here.
Napa County and all 5 Napa cities.
Here.
Novato.
Here.
Oakley.
Here.
Pinole.
Here.
Pittsburgh.
Here.
Pleasant Hill.
Here.
Richmond.
Yes, here.
Ross. San Anselmo.
Here.
San Pablo.
Here.
San Rafael. San Ramon.
Here.
Sausalito.
Here.
Solano County.
Here.
Tiburon.
Here.
Vallejo.
Here.
Walnut Creek.
Here.
Roll call complete. Quorum established.
Okay, the first item on the agenda, as well as the last item, is Resolution 2021-03 to approve formation of the California Community Choice Financing Authority.
Thank you, Chair. And we are going to hear from Garth Salisbury on this item as well.
Good evening again, everyone. Okay, thank you. So in addition to me, we'll also be hearing from Mike Callahan, Senior Policy Counsel. Mike's been working very diligently and trying to see if we have an alternative to CSCDA as a potential issuer for these prepayment bonds. Also with us tonight is Devin Brennan. Devin is a partner at Orrick, Harrington and Sutcliffe, and Orrick is jointly representing all the 4 CCAs that proposed forming the California Community Choice Financing Authority, the conduit entity that would be the issuer of MCE's prepay bonds, potentially these other 3 CCAs prepay bonds, and other CCAs that would want to join later to issue their own prepayment bonds. So that's what we're going to talk about tonight. Next slide, please. So the basic question, why create a conduit? As I mentioned earlier, we looked very closely as we pursued this prepayment transaction utilizing the California Statewide Community Development Authority, or CSCDA. It's an existing joint powers authority. It's really in the business of issuing bonds for other entities. But we were a little bit taken aback when they told us it would be $300,000 upfront and $100,000 a year for each transaction. Knowing at the time that some other CCAs were also looking at prepayment transaction, we decided to see what it would take to form our own conduit issuer doing the same thing that CSCDA would do. And what would that look like? And so, so we are proposing to create the California Community Choice Financing Authority, CCCFA. It's created by CCAs for CCAs. You know, it will improve awareness of CCAs in the capital markets. I mean, even though, as we say, this debt will not be specific and guaranteed by the CCAs, just having the whole notion of community choice out there will go a long way to just sort of educate the market as to what CCAs are, because they will ask, investors will ask, what's a CCA? So we think that's a good thing. We anticipate on MCE's potential transaction alone to save about $250,000 up front and about $2.5 million over the life of the transaction. And that's just with our transaction. Every other CCA that does a prepayment, and we do expect that they will also save similar amounts of money by not using one of the existing conduits that are out there. So that's really the tee up of this. I'm going to hand it over to Mike Callahan, talk a little bit more about the specifics of CCCFA.
Thank you, Garth. Can we go to the next slide? So I'm going to give you guys an overview of the Joint Powers Authority Agreement itself. There will be 4 founding members to the agreement. You can see their logos on the right there. Those are the 4 CCAs that are actively exploring prepayments. We are sharing the upfront costs to create the JPA. Each of the founding members will have a seat on the board, and there's a provision in the JPA that ensures that there's no fewer than 3 founding members to avoid consolidation of the debt on our balance sheet, which again is the accounting treatment, but not the responsibility to pay the debt. And it's open to other CCAs. So there are these 4 founding members, but we know that other CCAs are interested in pursuing prepayment transactions. And so as those CCAs will join, it'll further kind of defray the administrative costs of the JPA. Next slide. And just a general overview, it's a limited purpose entity, and this is part of it being a conduit issuer. It's not intended to have staff or operations. It's intended to be very limited and limited to financing or refinancing energy prepayments. It's a JPA, and so as with all JPAs, the debts and liabilities and obligations of the JPA will not constitute the debts and liabilities and obligations of its members, in this case MCE. So anything we haven't separately committed to would not become an obligation of MCE through this JPA. Next slide. And just a brief touching on the governance, the JPA board will be composed of the founding members' CEOs or their designees. Each member will have an equal voting share. Majority vote of attending members will work for simple changes like initiating a transaction or adding an associate member. A 2/3 vote of the entire board for more significant changes like adding founding members, and a full board vote for the most significant changes like changing how to make amendments to the JPA agreement. And some of those most significant changes also require approval by each member's own board, as well as the board of the JPA itself. Next slide. Just highlighting a few key features, the JPA would allow CCAs to initiate prepayments independently from one another. And MCE is planning to issue a prepayment just on our own, so not jointly with another CCA. It currently limits the membership to CCAs, and the administrative costs are going to be shared equally among the members to align with the voting power. Next slide. Wanted to highlight a few risks and mitigants. The top 2 here are actually copied over from the last deck and were spoken about. And this is assuming MCE has a live prepayment transaction. But if there's a default on another transaction from another CCA that's part of the JPA, that would not impact MCE's separate prepayment transaction. Similarly, if another CCFA member went bankrupt and MCE had a live transaction, that would not impact MCE's transaction. If there were bankruptcy among, and this is directly to the question that Dr. Wilkinson raised, if bankruptcy among CCCFA board leaves less than 3 founding members, we risk the consolidation of the bonds on MCE's balance sheet. And again, just the accounting treatment, not the responsibility to pay those bonds. And we have some options to mitigate that risk. One would be to transition any associate members to a founding member so that we have 3 folks as founding members at least. And if there weren't other associate members, we could consider amending the JPA agreement to open up membership beyond CCAs to include other public entities. And given the low cost that this JPA would have its members pay to issue debt, we expect it would be an attractive opportunity for non-CCA members. Next slide. So the recommendation from staff is to adopt resolution 2021-03 to approve the formation of the California Community Choice Financing Authority. And with that, I'll open it up for questions.
Anybody have questions? Director.
Tom, I did. Oh, go ahead. Barbara has her hand up as well.
Well, I'll see through. I'll start with Director Fong. Go ahead.
Hi, thank you. Thank you for the presentation. A couple of questions. One, if there is a default or I'll call it a default of our bankruptcy, what is the effect on consumers and what they pay for rates? Will there be, what do you foresee? Will there be a retro to prevailing rates? Will there be a catch up to make up for any delta that may have been lost that needs to be realized because now you've invested in a number of projects? So you've earmarked those savings that you now need to find dollars in order to continue to invest into those projects. What's the effect on the consumer?
Yeah, Garth, if you wanted to answer that, welcome to. But I think the big risk, if it was another entity, another CCA that was a member of this JPA that had filed for bankruptcy, that it shouldn't impact MCE's rates, because a default of their obligations wouldn't bring their debts and obligations to become the obligations of another member. If we had one of those entities fall out of the JPA, the pro rata share of the administrative costs that we're paying would go up. But we're expecting those to be very modest, that the JPA will not have full-time staff, that the staff of the members' CCAs will be doing a lot of the work associated with operating the JPA. So it should be a very limited impact to the rates, and just again associated with the administrative fees. I don't know, Garth, if you have anything you wanted to add to that.
Director Kohler.
Yeah, I think you may have touched on it, Michael. Thank you. Just what are our estimate of admin costs? I noticed the JPA agreement talks about appointing a part-time or full-time general manager and the possibility of appointing more. And the only reason I'm asking this is I know when we formed Cal CCA, which has given us tremendous benefit, I think we pay a little bit more than $500,000 a year. And I just want to make sure that whatever we're going into, we're not going to have, such a huge amount of admin costs, hiring staff as needed, that we're really not going to see the kind of savings that we're hoping for. So quick question. Thank you.
Yeah, it's a legitimate question, but this JPA is really just designed to be a conduit. It's not going to have, certainly not contemplated currently. I guess maybe if there ended up being like 20, 30 prepays done through this entity, maybe we might see a need in the future to have some sort of permanent staff. But Director Kohler, that is not the intent or expectation here at all. This is a conduit. It's simply there to be an issuer. There'll be very little, if any, sort of administrative tasks necessary. Certainly on day-to-day, week-to-week, even month-to-month. All of the operational aspects involved in the prepayment go to either the prepaid supplier or they are retained by MCE, which is what we're doing currently with the PPAs. So that kind of language is there really as a sort of a just in case kind of thing, but there is absolutely zero intent that we have paid staff at CCCFA.
Mr. Tracy, did you want to respond? I see your hand up. Not.
And Jim, you're on mute if you wanted to.
Did you want to respond?
Yeah, just real quickly, SMUD had 4 JPAs, and I think JPAs require a treasurer, and I'm not sure what else, but I know for my part, I was appointed the treasurer for each one of the JPAs at no additional salary. So the only cost that SMUD had for their JPAs for financing some of their projects was essentially some auditing costs that were minimal.
Yeah, right.
Director Athos.
Thank you very much. Is there any confusion over the fact that according to that section 4.10 regarding the fiscal year that they work on a January to December and we work April to March 30th, I guess? So how does that work in terms of this?
I'll invite Garth to jump in with technical details, but not several of the founding members were working on different fiscal years. And so, we just picked one that kind of worked for the group, but as I understand, it shouldn't have a significant impact on administering the JPA.
Okay.
Yeah. Director Haroff.
Just real quick, I just wanted to get a point of clarification on that one. I think it was the second to last slide on what happens if through bankruptcy or other means we end up with fewer than 3 founding members represented on the board. And one of the solutions to that would be to go out
Still on Zoom. How you doing?
And invite other entities. And it wasn't clear to me that we would be limited to CCA entities, but could be non-CC entities if they met certain criteria. How would that work? And wouldn't that kind of compromise if we went outside the CCA world to do that? Would that have an impact on the mission of this entity?
Go ahead, Mike. You can answer that one.
Yeah, I think as we're packaging it today, we're limiting it to CCAs, and there's a couple reasons for that. One, so that we have sort of control over the entity, and just to kind of keep the decisions and discussions simple. We would be well served if other entities joined this JPA, and again, in the sense of defraying the administrative costs. And I think if we need another founding member to ensure that we've got the proper accounting treatment, there's a benefit there as well.
Right, but that would be if it was a CCA, another CCA somewhere else in the state of California that were to come in and play that role. And I guess my question is it conceivable that if no one stands up in that community to do that, and we would be looking at a non-CCA entity to play that role, how would that work? And frankly, how would that be perceived if we were going beyond the original mission, which is to provide this tool for the CCA world?
We would need to amend the JPA agreement to allow non-CCA entities to join, and we considered this in the drafting of the JPA agreement. So that would be one step that would have to be taken. They would be public entities, so it would likely be a municipal utility. So I think in terms of the reputation, how that would be perceived, I think that it wouldn't be problematic. I think, we're often clumped in with municipal utilities in terms of, the business model and how we're viewed, more so than with investor-owned utilities or other direct access providers. And so I think there's an association there that folks would make that wouldn't create sort of reputational issues.
Director Mongan.
Thanks. Just a quick question about the CSCDA versus the JPA. I was just surprised to see the huge discrepancy in cost, and I just wonder if you could speak a little to why that is. Are there additional benefits or things if you go with the CSCDA that justify those higher costs, or what's going on there?
Now, I would say in a past life, when I would work on these we've used CSCDA when we needed to create a JPA to do an issuance, a bond issuance. So, and the fees were much lower than that, Director Monga. And I don't know why they specifically quoted such high fees, but I think that they see it as an opportunity because these prepayments do save money for the entity, and they say, listen, we can make ourselves available. Quite frankly, CSCDA is a bit of a cash cow, and they have literally thousands of bond issues out there that they receive fees from in different amounts depending upon the type of bond issue. And I can't speak to them and speak to the motivations for this fee structure, but it was very high in comparison to what I had seen for other situations where they were the conduit issuer for a certain type of bond issue. So that's all I can say about it. It really did, though, precipitate the whole notion of, hey, why don't we form our own? And we'll all save money, and it'll be, again, a CCA JPA for CCA. So that was really the motivation behind it.
And just to highlight some of the benefits we'd get through CSCDA, we wouldn't have to devote staff time to running the JPA. Our understanding is that's going to be a very light touch. And then, we don't have to manage the risk of not having 3 founding members and losing the beneficial accounting treatment. So those are some of the benefits.
Yeah, good points, Mike. Yes, good points.
Director Harrell?
I raised my hand when I was at a moment ago when I didn't see anybody else having their hands up. But as soon as we conclude this conversation, I'd be happy to move the resolution.
I think we have one more speaker, Director Wilkinson. Then
yeah, I saw that pop up. Yep.
Go ahead.
I just had one. I was just thinking back on the structuring this, and I was curious to know. And one question I'd never asked really was, why now? You've got 3 other CCAs interested in participating in this JPA, and as you said, there's not been. These deals have been dead for pretty much a decade now because the spreads weren't there, and the spreads aren't really there now either. So I guess my question is, why now?
Well, I would say that the deals haven't been dead for a decade. What there hasn't been is so many deals in California. There was, and I don't know if John Norman is still on. He might not be. John, are you still on? No, I'm sorry. No, he's not. But there were actually quite a flurry of deals around 2017 and 18. Again, there was this one SMUD deal in California. So why now is because the CCAs are now just focused on this. Really, this whole idea of being able to prepay PPAs. It's a relatively new concept. As I said, it's been done for electricity and for gas and so on, but the whole idea of prepaying the PPAs and novating, all of that. So all of this sort of technology has developed more recently. And again, is why, as I mentioned, 2 or 3 other CCAs are also looking at prepayments as well. So that's sort of the why now. And the why CCCFA is because, again, of the economics and the savings.
And the why now, because the bankers came to the different CCAs with a proposal, or this emerged out of CCAs?
No, I think initially the banks came to CCAs. They came to us, and again, I was familiar with prepays before this, but yes, and when the other CCAs, believe me, we've had tons of conversations with them. And when we started talking about prepays, I personally have done a presentation to Cal CCA on prepayments. So, it's being socialized around the industry. So, as I said, a number of them are looking at doing these prepayments.
Sorry, go ahead.
I was going to say, so it's the financial engineers within the banks who have come to make the proposal to the CCAs. What do you say?
I'd actually like to correct that, kind of just historically, even before Garth's time. This is something that we were talking about at the board level, and began reaching out to a couple of different banks that we had heard had done this. When MCE was initially formed, we had a advisory board from municipal utilities, including SMUD, and financial institutions and other public utilities that helped advise. And this was one of the structures that was recommended as a benefit of forming a CCA, kind of the ability to take advantage of our tax exempt status and pass that along to customers. And that was one of the discussion points in some of our early thought pieces before MCE was formed. So just certainly that was a little bit before Garth's time. So no fault of him not knowing that because he hadn't joined us yet. But I just wanted to provide that little historical tidbit.
And then I just wanted to provide a couple additional points. You know, one thing that's as I understand about these deals is that you can't really wait for the window to open to start working on the deal. You kind of need to be prepared to execute the deal when the spreads in the taxable bond market and tax exempt bond market's there. And so we're trying to get ready for when that window opens so that we don't have a hesitation that where we end up missing the window and the window closes. We've also been keeping an eye on the spread, and it appears that the window may open as early as June. And just wanted to flag that, you know, these deals currently are dependent on the spread between the taxable and tax exempt bond market, but MCE has also been pushing along with a concerted effort, I think, across the country to try to get a provision in some of the federal bills working on stimulus that could make this opportunity open all the time. So there's just a couple of timing considerations I wanted to share.
All right, Mike, can you explain that in terms of what legislation you're looking for?
Yeah, it would basically, I don't know, Garth, if you want to break it down.
No, yes, there's, and it's been talked about a lot in the Wall Street Journal recently as part of the infrastructure bill, the Biden infrastructure bill. There are provisions of what are called AIB bonds, which are taxable bonds that are subsidized to make them look like tax exempt bonds. So again, there was similar bonds after the financial crisis called Build America bonds, taxable with a subsidy that equates to the tax exemption. And so what Mike is referring to is the fact that we're waiting for these two markets to have a spread that will allow us to get the savings we want, but with an AIB bond or a taxable bond with a subsidy, that savings should be there all the time. So it's not two markets having to, sort of go counter to allow us the opportunity. We should be able to do it whenever we want to do it, just based upon, the necessity to try to prepay more of our PPAs. So, but again, that would be a federal tax legislation that would make those bonds available not only to MCE, but any municipal entity that wanted to issue a taxable bond with a subsidy as opposed to a tax exempt bond for any purpose that is allowable under the tax law.
Tom, you're on mute.
I'm sorry, I'm muted. Director Thier.
Thank you. I just wanted to ask through the chair, Chair Butt, I'd like to make a motion if it's time for motions.
Well, I think it's about time. Let's see if we have any public speakers first.
Great. Thank you.
Do we have any public speakers?
I see no raised hands, Chair Butt.
Okay, it is now time for a motion. Go ahead.
And I will move that we adopt Resolution 2021-3 to approve formation of the California Community Choice Financing Authority.
Okay, is there a second?
Second.
Okay, second by Perkins, motion by Thier. Call the roll, please.
Belvedere?
No.
I'm sorry, is that a no?
No.
Thank you. Concord?
Yes.
Corte Madera?
Yes.
Danville?
Yes.
El Cerrito?
Yes.
Fairfax?
Yes.
Lafayette?
Yes.
Larkspur?
Yes.
County of Marin?
Yes.
Martinez?
Yes.
Mill Valley?
Sasha, you're on mute.
Mill Valley, Napa County, and all 5 Napa cities,
Yes.
Novato,
Yes.
Oakley,
Yes.
Pinole, Pittsburgh,
Yes.
Pleasant Hill,
Yes.
Richmond,
Yes.
San Anselmo,
Yes.
San Pablo,
Yes.
San Rafael, San Ramon,
Yes.
Sausalito,
Yes.
Solano County,
Yes.
Tiburon,
Yes.
Vallejo,
Yes.
Walnut Creek.
Yes.
Motion carries. Roll call complete.
Darlene, did you hear me after all? My mic went off. It was a no.
I did not. Okay. Thank you.
Sorry about
Okay.
that.
Darlene, the city of oh, I'm so sorry, Chair. This is Devin Murphy from the city of Pinole. That was a yes vote if you didn't hear.
Thank you, Councilman Murphy.
Okay, that is the end of our agenda, and unless somebody can think of a good reason not to, we are adjourned.
Good night, everybody.